This guy, this defendant, got indicted on January 13th. He called me. He said, Lamar, I seen your speedy trial video. I need some help. I helped him out, helped him draft up his speedy trial motion. Simple Google search, simple AI, simple tools that we have, right? Get you a lawyer, whatever. He's definitely gonna get a lawyer, but he wanted to get this in before he was able to get a lawyer. So you can do this now before you even acquire a lawyer.
And see, this is what court-appointed lawyers usually file, generally to cover their ass, right? They enter a notice of appearance, and then they defendants notice non-waiver all constitutional and statutory rights. So basically, he's saying, yeah, we're not waiving our right to speedy trial, but you can only get your speedy trial right if you demand it. It's not implied. This is too vague. And I've seen too many times in the dockets I've viewed in the short period of time that new media in existence, 90% of these court-appointed lawyers, people like Michael Connolly, people like John Bradley, they file this. So it doesn't pushes the state's hand to take you to trial. And 9 times out of 10, the state is still building their case while you're sitting in county lockup, right? The time is not of essence. Time is not on your side. Once you file a demand for speedy trial, it forces the state hand. And if they don't take you to trial within 2 calendars, 2 terms, right? The current term and the next term, it's an automatic discharge and acquittal, right? They can't delay it. They can't do all that. It doesn't matter. Statutory is clear. It's clear cut. OGC subsection 17-7-170. Go look it up. It tells you. That's why it's very important that you do this, that you file this demand for speedy trial. Tell your lawyer, whoever, they need to file that by name. Because see, a lot of times these relationships that these even defense attorneys that you pay money to, they'll have you sitting waiting. Well, we're waiting on the trial, waiting on the calendar call, we're waiting on the calendar call. You file that speedy trial, it forces the state's hand. This is why it's in place. That way they can just draw it out and it's continuous. If they don't take you in front of a jury in 2 terms, automatic discharge and acquittal, you'll stop sitting in that county for 2 years. You'll stop it. You'll make them do their job. You'll make them force the case. If they got a case, they got you indicted, let's go. But we know I've seen so many times, to get an indictment, it doesn't take a reasonable doubt. It doesn't mean that you're convicted. It just means they're ready to take you. They say they got a case strong enough to take you to trial. Hey, let's do it then. If you got an indictment, let's go. This guy got indicted on the 13th.